we are now moving into the agenda and the adoption of the agenda. Under Convention Special Rules of Order, the Libertarian Party, Rule 1 has a standing order of business for a regular convention.
All
that shall
right,
be as
guys.
follows. Call to order, Credentials Committee
Here's
report,
what we're
adoption
going
of
to
agenda,
do.
Treasurer's report,
We are going
Audit Committee report, Bylaws and Rules Committee report, Election of Judicial Committee,
provide a little bit of guidance as to what's going on here. Now, I know for a lot of you guys, this is your first time being involved in a Libertarian Party anything, especially Libertarian Party National Convention, and you're probably wondering, what is this craziness going on? So here's what I'm going to do. I am going to provide some guidance as to what this madness is. Right now, we're basically dealing with what we usually see at the beginning of any convention. And that's just dilatory nonsense. People trying to gum up things, trying to slow things down. That's usually because they believe that their side on whatever issue isn't favored by the current setup. So they're trying to just push for any kind of random change, any kind of unnecessary counts, et cetera, et cetera. So that's what's happening right now. As this goes on, I'm going to do my best to clarify what's actually happening in this stuff, to give you the kind of guidance that I've developed, or the kind of experience I've developed over the last several years, serving as vice chair for 2 terms, as a representative at large for 1 term, and having attended several national conventions so far. All right, let's see where they are so far.
Officers and at large.
I do not wish to skip ahead, but I have a point of order.
Okay. So
let's see what this point of order is.
Delegate Tyler Rowe raises a point of order that his point of order is being relegated behind points of privilege. Mr. Rowe, do you have a point of order or not?
Yes, sir. I was to be recognized behind Maryland Delegate Ahmad, and I was removed when you recognized me for my previous point of order.
Yes, once you get recognized, you do get removed from the list.
That was for a different point of privilege.
Okay. Do you have a point of order right now?
Yes, that I was removed from the queue regarding the current business.
That is not a point of, I mean, it's technically a point of personal privilege, but what would you like me to do?
I would like to be reinserted behind Maryland Delegate Ahmad.
All right, interesting.
So you want to be in the queue to speak, to be recognized for business after Maryland Delegate Ahmad.
Yes, sir.
If you can take care of that and put that in the raised hands list, we'll do that. Thank you. Arizona Delegate Robert Pepiton has an interrupting and privileged motion.
Yes, Mr. Chair. I move that Karen Ann Harlos be removed as convention secretary and the body nominate a replacement to serve for the remainder of the conventions.
What?
Mr. Brown, is this in fact interrupting?
Mr. Chairman, I do not believe that is an interrupting motion. That's
just a bizarre emotion. Now, again, what are you seeing? People are just playing kind of silly politics over here. I mean, you're not going to replace the secretary in the middle of the agenda adoption just for absolutely no reason. To replace a sitting officer, I mean, it requires, I don't even know how many votes. It requires a lot of votes. They're never going to get anywhere near that. This is just a silly, ridiculous way to delay what's going on. I mean, that's just a nonsense motion. And you're going to see a lot more of those nonsense motions that are designed to delay this. Remember, a lot of people don't want to see us succeed. What do? They try to gum up the gears as much as they can. All right, let's get back to this.
Report.
As far as the comparison between a place for the convention and an electronic place for a committee or board meeting, I would suggest that it would be in order to adopt an agenda that is more similar to what was passed by the LNC's call of the convention, that we do nominations at this time and not the other items of business until the second sitting.
I rule that this is a regular convention called by the LNC, who set the time and place for the convention. All of the convention bylaws apply, including the standing order. And the delegates have the power to adopt whatever business they want. Do you want to appeal that ruling, Mr. McVeigh, and get this over with?
I do. Thank you, Mr. Chair.
second.
I assumed there would be a second.
Mr. Chair,
Ms. Harlows?
that is the same point of order I was going to raise. Can I be put in the speaking line? Or what do I do to speak that's not interrupting?
One second.
You're making it.
Somebody already started.
It's been,
We will move through debate as long as it takes.
So I just want to be added to debate, is all I'm saying.
Well, we have a long speaker line for people that wanted to get to business, but since we're going to be dealing with the parliamentary issues first, we will deal with them first. So if we can create a second speaker queue for this appeal for the ruling of the chair, and then we'll just have everybody put their hands down and we'll take new hands. If that's something that can be done technologically, we will do that. So there's a point of privilege about the agenda to be adopted. That's not in order yet. There is.
All right, guys, let me explain what's happening over here. To those of you who are new, this might look just bewildering. What in the possible world are they doing? Here's what's happening right now. This is a people who don't want there to be an online convention because they believe they're going to have a better chance with an in-person convention. So what they're trying to do here is try to call the convention itself out of order, try to call the secretary out of order, try to censure the chair. They're going to try to do everything because they're trying to make the online convention not work. People who didn't want the online convention are now trying to monkey wrench the online convention. It's not surprising. It's not expected. I still think it's a little bit juvenile.
A point of order. Mr. Lawhorn, you just have to unmute yourself now, I believe. All right, so Victoria Ikemi from Oklahoma is where Mr. Lawhorn would be making his point of order from. If we could unmute Victoria Ikemi.
And am I being added to that queue as well, Mr. Chair?
I believe you've raised your hand, so I believe you're being put into the speaker queue. There are assistants trying to update the speaker queue as we speak.
Okay, it's just because I did ask to be put in it.
Ms. Harlows?
Thank you, Mr. Chair.
Thank you. They're working on it. Mr. Lawhorn or Victoria Ikemi from Oklahoma, can we get Mr. Lawhorn? Wait, Whitfield? Mr. Lawhorn?
Test.
Yes, I can hear something.
Yes, Mr. Chair, the creation of this online convention, which was taken under emergency ruling, also included a proposed agenda for this convention in particular. And therefore, if this is going to be a valid convention, according to what the LNC ruled on, the agenda should be the one that is within the motion that was created that created this special session.
That's incorrect, Mr. Lawhorn, and the reason it's incorrect is that the bylaws do not allow the Libertarian National Committee to set standing orders of business for a national convention. They are only allowed to set time and place, and the delegates in convention are allowed to determine their business.
Okay, guys, let's go over that a little bit because I know that part might have been pretty confusing. All right. The LNC said we're going to have a convention just to nominate presidents and vice presidents. The thing is, once the convention is called, you can do anything you want during the convention. Here's why that rule stands. The belief is that the entire convention has more sway than just the LNC. The convention body is the overwhelming force here. So if the LNC passes something, the convention can always override it. So the LNC can say we're going to have a convention at this time, and yeah, I guess those 17 people can say, and here's what we're going to discuss, but if the other 1,000 people say, no, we're going to discuss this other stuff, there's nothing LNC can do to stop them. See, in a convention, there's a lot of ways you can change the direction of it. This is what people are afraid of in the online convention. You can have a suspension of the rules that requires a 2/3 majority. With a suspension of the rules, you can then say, now we're going to do literally anything at all. Change our name to the Republican Party. Fire the chair. You can suspend the rules to consider literally any topic. Now, it doesn't mean that's going to pass, but you can't control a convention. a suspension of the rules is in order at like almost any time, except for during a vote or something like that. But it is suspension of the rules is in order at almost any time. Amending the agenda, which is what they're doing now, that you can do at the beginning, but the agenda doesn't matter because you can always, always, always suspend the rules. That's what people are worried about, that this online convention is going to have everything, full platform bylaws, everything discussion. So this is why it's important for delegates to make sure that you understand what's happening here. If you have questions, please ask your delegation chair. All right, let's catch up to these guys.
Appeal the ruling of the chair, please.
We're already brief, and I'm going to go through the list as prepared by the assistants, and we're going to go in the order I call people. I believe that list is available for people to see. I see it at least. And we're going to start with Maine Delegate Tyler Rowe. Mr. Rowe, go ahead.
Yes,
All right,
I
what
move to
comes
call
next?
the previous question, requiring a 2/3 vote.
Mr. Rowe would like to move to end debate. And what we're going to do, I will not entertain a motion to end debate before there's been any debate. We're going to allow at least a couple of speakers so that there can be some debate, because it is necessary to have speakers speak against my ruling in order for the body to consider it. But after there has been debate on both sides, I will once again entertain a motion to call the previous question. California Delegate Alicia Matson, go ahead.
Now, Alicia's often pretty obstructionist a lot of things, and she's an expert at Robert's Rules, so she knows what's going on here. Let's see what she
I am
does.
going to speak against the ruling of the chair, against sustaining the ruling. This meeting is being conducted in a way that violates all the fundamentals of what a meeting is, including starting on page 1 of Robert's Rules for simultaneous oral communication, and that's not possible, and we're locked away in little cages so we can't see or hear each other. Regarding the bylaw discussion of whether or not online meetings are a place, Robert says we need bylaws authorization to have electronic meetings. There's not one for conventions. We have one for boards and committees to meet in electronic meetings, but we do not have one for conventions. And
this is a really tricky area, guys, because the simple fact is, Alicia is right. Roberts added an additional thing to allow for bylaws for online conventions. And then the LNC added additional stipulation that Robert says that if you want to have an online convention, you have to make some rules for it. And the LNC did make rules for it for LNC meetings and for platform meetings. There is no actual rule for an online convention. So what Alicia is saying is that because that was never done, this entire convention is in its nature out of order. And honestly, there's not too many people who know Robert's Rules better than Alicia does. So let's see where this goes.
the bylaws, just like it says LNC sets time and place for conventions, it says the same thing for LNC meetings, yet that was not sufficient to authorize an electronic meeting. And we have no similar bylaw authorization for electronic meetings for conventions. And I will point out from the principles of interpretation in Roberts that when the bylaws authorize electronic meetings for boards and committees and says nothing about conventions, that is to be interpreted as a prohibition for any other groups to use the electronic meetings. So I disagree with the ruling of the chair, and I will be voting no on the question of sustaining the ruling of the chair.
Okay. I'm going to make something very clear. South Dakota Delegate Carl Abernathy continues to abuse the Q&A. If Mr. Abernathy continues to abuse the Q&A, Mr. Abernathy will at some point be found to be disruptive to the convention, and the body will decide whether or not to eject him. So I would suggest to Delegate Abernathy that he stop abusing the Q&A. Michigan Delegate Lawrence Johnson.
That, by the way, is a common thing to do. So to use privileged motions, in Robert's rules, you have some motions that are privileged, points of information, points of order. It's often, and those take precedence over debate, and people often use them to jump the line in debates. I've done it lots of times. It's a common enough technique. And the online version of doing that is to use the Q&A to use it for something other than asking a question or having a privileged motion. All right, let's see where we are so far. Whoa, we're having some tech issues. Hold on, guys.
We can then move to a vote on it. Do you support ending debate on the appeal from the ruling of the chair?
So we're ending the debate, not the whole debate, just on the debate on whether or not to appeal the ruling of the chair. So is the chair's ruling right or wrong? I mean, it'll probably pass because we got this whole thing set up. It would be insane to shut it down now.
The poll has been out now for, looks like just over a minute, maybe a minute and a half. Again, a yes would end debate.
Just debate on this
no
one
would
topic,
allow
not all
us
debate in the whole world. Just whether or
to
not we're
continue
going to
debate
overturn the ruling of the chair on this
on
topic.
the ruling, on the appeal from the ruling of the chair. There
And
are
guys,
about
this-
5 seconds left for people to vote.
This objection was expected.
Chair, can I
right?
share information with you, sir?
Yes, Ms. DeSisto?
When we relaunch the same question, support to end debate, it does not reset the clock. And
Okay.
so this has been up for 1 minute and 19 seconds
Okay.
as of right now.
All right. Well, then I will give people a little more time. I'm sorry for anybody who thought I was going a little too fast. So if you can just tell me when we get to that 2-minute mark. Right now I have 906 out of 968 have voted in the poll. Again, this is whether or not to end debate on the appeal from the ruling of the chair.
So we're not actually voting whether or not the chair is right or wrong. We're voting whether or not to end debate on whether or not the chair is right or wrong right now.
Polling will end in 10 seconds.
You have 10 seconds left if you would like to vote.
This is just to
And
end
at the
debate
end of polling,
on
we
whether or not
have
we're going to overturn
912
the ruling of the
total
chair.
votes, 673 in support of ending debate, 212 opposed to ending debate, 27 abstentions. That is clearly more than 2/3.
So now we're gonna
Debate
end
will
debate.
be ended.
Ending
I will
debate
say before
on whether
we
or not
move to a vote on whether to sustain the ruling of the chair, that this being a regular convention and in order is the thing that allows our presidential candidates to be nominated. It allows us the best way to get through the ballot access challenges we are bound to face. And it is up to these delegates at convention how they're going to do their business.
Point of order.
Who has a point of order?
I have a point of order, Mr. Chair.
Who was
Vote,
that?
Chris Weiss from Kentucky. A vote was just taken to end debate, and yet you are continuing the debate. I
Yes.
think it's out of order.
Mr. Wiest, you are incorrect. I'm actually exactly in order. There's a privilege with appeals from the ruling of the chair that the chair gets to speak to his ruling at the beginning and gets to speak again at
Nick
the
is
end.
not right on this. I don't think Nick is right.
That is correct, Mr. Chairman.
Thank you.
He gets to speak at the end, but I don't
So
think he
as I
gets to
was
speak
saying,
after debate is closed.
This
Now I could be
body
wrong. Nick is an
controls
expert,
the
so
business of the Libertarian Party.
we're gonna yield to
This
the
body
experts
gets to
here.
decide its own agenda. This body gets to decide to be in convention. This body gets to nominate presidential and vice presidential candidates, and this is a convention.
All right.
So if you sustain my ruling, we can proceed in that fashion. And if you overturn it, we can go to this being something other than a convention that has special rules that constrain this body. So we will now proceed to a vote on sustaining the ruling of the chair.
Now, if
I
this
believe
ruling
the
is not
question
sustained,
written, should,
we're not going to
Mr.
be on the
Brown, can you
ballot.
just
So I
remind
hope
me
it's
of how to put it?
sustained. In order for us to be on a ballot, we have to hold
let's
a
not
full
poll.
convention.
No polling yet, no polling yet, no polling yet, no polling yet. Sorry.
Yes, the question should be, shall the ruling of the chair be sustained?
Shall the ruling of the chair be sustained?
If the ruling is not sustained, we won't be on the ballot.
So
That's
a
how important
yes
this is
vote
right now.
would uphold my ruling. A no vote would be to overturn my ruling.
That is correct.
Okay. So if we can do a poll, shall the ruling of the chair be sustained?
And if the ruling is not sustained, then the Libertarian Party won't be on the ballot in a lot of
Yes,
states.
no, and abstain.
A lot of laws require us to have a full convention in order to nominate people. And if we don't have that,
Point
then
of
we have a major
information.
issue.
Yes, Mr. DeRazio?
There are several people asking what your original ruling was that we're supposed to be upholding or overturning.
Yes. So the chair's ruling was that this is a convention, that the standing order of business from the convention, from the bylaws and convention special rules is the initial matter that we are dealing with, and the delegates have the power to adopt an agenda of any sort, and are not limited by a vote or other action of the National Committee as far as the business that can be done here. It is up to the delegates whether or not to adopt the agenda. That is the ruling. Are we close to having the poll ready?
The poll is ready.
The
Chairman.
understanding that
So this vote will be on whether or not the ruling of the chair should be sustained. A yes vote sustains the ruling of the chair. A no vote overturns it. And the poll is out.
Let's see what the poll says. Are we going to be on the ballot or not? Or are we going to be shooting ourselves so badly in the foot right now? Listen, I don't like online conventions any more than the next guy, but I like not being on the ballot even more. Now, realistically, we shouldn't have to do anything to get on the ballot. The ballot should be a blank piece of paper where you write whoever you want. But Democrats and Republicans have co-opted the ballot. They've created a government ballot.
We're about 35 seconds in. We have votes from about 870 of 969 people logged in.
All right, let's see what happens here.
Again, the poll is, shall the ruling of the chair be sustained? A yes vote sustains the ruling of the chair. A no vote overturns it.
And no vote takes us off the ballot. Now, even as a full convention, we can then vote to restrict it, and that's probably what's going to happen, right? I mean, we're not going to have, I mean, I'd be shocked and amazed if we were going to have a full convention here. I mean, that would be just too stupid for words. But what it has to happen is we have to have the option to do a full convention, choose not to do it. That keeps us on the right side of the law and lets us make sure that we're staying on the ballot.
We are a minute and 36 seconds in.
Ooh.
Ten seconds left, a little less. We have 926 total votes so far.
All right, let's see what happens. Because remember, we need a yes vote here. Without a yes vote, we can't get to the ballot.
620 votes to sustain the ruling of the chair, 274 votes to overturn the ruling of the chair, and 33 abstentions. The ruling of the chair is sustained.
Mr. Chair, please repeat those numbers. I'm not sure I got them right.
Somebody close that window, or I close that window.
I can help you. 620 yeses to sustain the ruling of the chair.
All right, guys, here's what this means. It means we're going to actually be able to get on the ballot. If they had gone with a no vote, it would have invalidated this convention. We'd have had all kinds of legal challenges, and we're going to have legal challenges anyway. We would have had all kinds of legal challenges and not been on the ballot in a lot of states. So this is, I'd say, good news.
In order. We are going to proceed to motions related to the agenda. I assume, is this speakers list that I'm looking at, was that for the ruling of the chair, or is that the actual speakers list for business?
Point of order, Mr. Chairman. There was a call for division.
There was a call from Mr. Hagopian for division. I find that call for division dilatory.
Dilatory, by the way, guys, means that it just looks like it's there to waste time. It's not a legitimate call for anything.
You're not going to get a majority to overturn my ruling out of what was clearly well over 2/3. It's not happening.
And listen, guys, Nick is a great presiding
The ruling of
officer.
the chair.
No, we're not doing this all night, guys.
So what Nick is doing, he's saying that some of these things are dilatory. In other words, they're just designed to stall and waste time.
Right.
This happens a lot on contentious debates.
So is the speaker queue I'm looking at that has Utah Delegate Stenquist? She was the last one to speak, but that was on the ruling of the chair. Is
That's
that
classic.
the right speaker's queue, or should I be using a different
He
speaker's
ruled the
queue for
appeal
business?
dilatory.
That's that's the one for the ruling of the chair, but that's who has their hands up. So I don't really know how to
What happened
refresh
to-
it unless we lower all the hands.
Did we have another list? We
Could be
did,
below.
but it went away.
No, it's there. It's there, but it's not in sync with the people whose hands
Well,
are raised.
clear this list because we're not appealing the ruling of the chair anymore.
Please place me in the other list as well, Mr. Chair.
Do you not have the hand raise?
I do not. I apologize.
Okay.
All right, we're just gonna have to retype it.
All right. So people that want to be recognized to do business. I'm going to go to Tennessee Delegate Tricia Butler.
Mm-hmm.
Apologies, Mr. Chair. I do. I've raised my hand. Thank you.
Oh, good. I'm going to go to Tennessee Delegate Tricia Butler.
Oh, mute that,
Apologies,
please.
Mr. Chair. I do.
Didn't we already have another list for speakers? And I was lower on it, actually.
I know, but it's technical issues. We're trying to deal with them.
Okay, well, I want to go farther down the
Well, I'm sorry.
Look,
You
I
can see
move
it's
to
already
accept
taxing
the
Nick's
agenda
patience. And
that
Nick
was
is the most
agreed upon
patient
by
guy
the
in the whole of
LNC.
the earth.
Okay, so your motion, as I
Second.
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 All right, let's go full
There,
screen.
it's assumed, guys. You don't have to say it. So your motion is to amend the order of business for this convention to not be the standing order of business as defined in Rule 1, but to be amended to be the order of business for the first sitting that the LNC adopted in their motion on May 9th. Is that correct?
Yes, Mr. Chair.
Okay, and I believe that agenda, I do not have that document in front of me.
All right, guys, let's talk about what's happening right now. Right now, you have a general. The bylaws have a set agenda for the convention. It's always changed. It's always thrown out, right? But this time, the changes were kind of discussed beforehand, that we were just going to do presidential and vice presidential nominations, not bylaws, debate, and platform, and everything like that. So that was the sort of understanding, the agreement. Now, Nick ruled that we could do other things if we want to. Maybe it's not such a good idea, but that we can. So it was sustained that we are allowed to do other things if we want to, but it's still a terrible idea. So now we're going to debate, are we going to go with the actual plan we've made or have some other crazy substitution? Let's find out.
I have about 18 screens, and that's not one of them. But I believe it had this setting was going to be credentials, adoption of the, and I'm going to get through the speakers queue and I'm going to go through it in order, but I anticipate that there's going to be people who want if we know that there's going to be your standing order from the bylaws, and then there's going to be at least this motion and probably a different motion to have a different order of business. What is the most efficient way to get through it so that we utilize people's time well?
Mr. Chairman, I honestly don't know, but I do think that perhaps with a majority vote, the assembly could decide to first vote on this motion as is before taking up amendments. But honestly, I'm thinking off the top of my head. I do not know the best procedure for handling this.
All right,
When the parliamentarian doesn't know, we have a problem.
okay. I need that list back. All right, so we have the motion from Ms. Butler to adopt the agenda that the LNC suggested. I have Maine Delegate Tyler Rowe. Go ahead, Mr. Rowe.
Thank you, Mr. Chair. I move to amend the motion to remove any time bounds from the adopted LNC agenda. I am in support.
It's out of order because there are no time bounds on the LNC agenda.
Thank you.
Colorado Delegate Karen Ann Harlos.
And we're on debate on the amendment, Mr. Chair, just to clarify.
Yes.
Okay, thank you. I wish to speak in support of this amendment. This is a compromise that was agreed upon after speaking with many, many members of the party. And I do believe, I know the chair would disagree, that we will be opening ourselves up to potentially 51 legal challenges in states if we cannot prove that what we did at a certain convention was under emergency provisions that would allow us to deviate from what some people would perceive as not being in accordance with our bylaws, regardless of what we decided. Judges and other people might decide differently. And the safest route to ensure both our finances and our candidates being on the ballot is to do the minimum possible to get people on the ballot, which is to nominate them here and then ratify them in person. That is completely safe, rather than this very risky idea of trying to do everything. So I would speak in the interest of the party's finances and our candidates to adopt this amended agenda that was proposed by the LNC after
Don't
much
worry, we'll talk
research,
about what
much
this
thought,
is.
and much debate.
Okay, I'm gonna get to some interrupting ones. We have a point of personal privilege from New Hampshire Delegate Daryl Perry. The California Delegate Starchild is having trouble being able to vote. Delegate Starchild needs to work with his state delegation chair to get this resolved and try and get that done. We will work on helping people be able to vote, and we have technical support, and we're working as fast as we can. I have Oklahoma Delegate Todd Hagopian wants to appeal the ruling of the chair that his call for division was dilatory. I'm going to recognize Mr. Hagopian.
Oh, good God.
Go ahead, Mr. Hagopian.
All right, while we deal with these dilatory motions, let me explain what's happening over here. If we do an online convention and then that's it, and we don't have an in-person convention, a lot of states require an in-person convention by law, and so we're going to get legal challenges in all of those states. And those states don't expect to win the legal challenges. That's not the point. They don't want to win them. They just want those legal challenges to not be thrown out of court, all right? If those states can get us into court, they can tie up our finances, our resources, defund our campaigns. Remember, a Libertarian Party campaign, even a well-funded one, maybe raises a couple $1 million. Compare that to like the several $100 million raised by the Democratic or Republican campaigns. So if they can just go even like 5-1, they could sacrifice, say, $10 million of their dollars so that we go lose our $1 million and we're down to zero. That's what they're trying to do. They're trying to get us in court. So what Karen Ann was suggesting was that we do this. We nominate over here and then ratify at the convention, at an in-person convention. Here's a tricky area. We have that option. The in-person convention could very well choose to ratify somebody other than the person who's nominated today, tomorrow, and on Sunday. Let's catch up with them.
In order to amend the agenda, it only takes a majority if the agenda has not yet been adopted, and this agenda has not yet been adopted by this body.
That is the case if there is not a standing order of business that's already defined in the bylaws. When there's a standing order of business that's defined in the bylaws, it comes in as the proposed order of business and you have to move to amend it. And that's what requires the 2/3.
Okay.
I'd like to hear the parliamentarian's opinion, if he agrees with that.
All right, guys, let me explain that one. That one's going to be bewildering. Normally, before an agenda is adopted, it just takes a majority to change it. After the agenda is adopted, you need to have 2/3 to change it. So Jay is arguing we haven't adopted the agenda yet, so we just should need a majority to change it. Nick is pointing out, though, the default agenda, which is adopted by default, is in our bylaws. So we start out with an agenda. We don't start out from nothing. We start out with a clear and definite agenda, and then we have to alter it. So all changes, Nick is arguing, require 2/3.
This is Mr. Brown. I concur with Mr. Sarwark's ruling, and in fact, I have discussed this point with several other members as well.
I have a point of parliamentary inquiry from New Hampshire Delegate Justin O'Donnell, who asks about if a division is to count votes, doesn't the fact that they're numerically counted and already divided make it moot and dilatory and obstructionist? Often it is, and I will rule things dilatory if necessary.
Let's get caught up here.
Mr. Olson, which fundamental delegate rights are we violating?
Oh, good God.
Well, first of all, there are many delegates. I've been in contact with numerous delegates who are having technical issues, but I want to make my motion and then we can speak about it if you will.
You raised a privileged motion. So what motion do you have that is privileged?
I will get to that if you will.
No, you have to identify why you get to jump the queue before you get to jump the queue. So go ahead.
All right. So my motion is I move that when this meeting adjourns, it stands adjourned to meet in person at 9 a.m. Eastern Time at Rosen Shingle Creek in Orlando, Florida, or alternate site and date selected by the National Committee if that venue should become unavailable. I want to point out that this motion does not adjourn our meeting right now or set a time for its adjournment. It only establishes the time and location of our next meeting. This motion is the highest ranking motion in Roberts. It is not debatable and requires a majority vote.
I believe, and I will check with Mr. Brown on this, but I believe that would be out of order to set the adjournment for this meeting to be to a time and place certain.
Interrupting privileged motion.
Wait a second, let me finish talking.
Ooh, they're in trouble now.
That it would be out of order to make a motion to adjourn this meeting to a time and place certain in advance of this meeting, this convention adopting their initial agenda. I think that is out of order in the actual technical sense, in that you're setting the end of an agenda before you've adopted the agenda. Mr. Brown, do you agree?
I do. I understand the member's point, but I agree, Mr. Chairman. I believe you are correct. You need to first adopt the agenda.
Dr. Olson, do you want to appeal that ruling? Dr. Olson, did you want to appeal that ruling?
All right, guys, let's go over what just happened there. Dr. Olson wants us to set now where the in-person meeting is going to be. So at the end of this convention, the next meeting is going to be there. Nick is pointing out that we haven't started this convention yet. So you can't set the end of this convention before we've actually started this convention. Let's see where it goes.
That your motion is not presently in order. And then I will identify who had the interrupting motion once I hear from Dr. Olson whether or not he wants to appeal my ruling.
He's calling me. I think he lost it. Hold on.
Mr. Chair, I would appeal.
I appeal the ruling of the chair on behalf of Mr.
Whoa.
Olson.
Listen to me, because I'm not going to say it again. We will not have crosstalk. We will take things in order. We will not all yell at once. We will wait for Dr. Olson. Is Dr. Olson available?
Excuse me, Mr. Chair. He just called me to say he lost his connection, but I will appeal the ruling of the chair on his behalf.
You have not.
Or
been,
I will just. You
have not been recognized, Ms. Robeson.
Okay.
Thank you. Who had the interrupting motion? While I was trying to explain my ruling on Dr. Olson's motion.
Sit down, Montana delegate.
Mr. Dowd, go ahead.
I was attempting to to raise an objection to the consideration of the question.
All right. So what's happening right now with all this back and forth and nonsense? What's happening here is basically this. They are attempting to create essentially to bind what people are worried about here is that there's not going to be an in-person delegation or an in-person meeting at all. This presents big legal risk. It gives a lot of candidates major advantages and disadvantages. So why they're trying to bind the next thing even before this starts is that they're worried, and they're rightly worried, that people are going to just make this convention have everything. Platform, bylaws, LNC nominations, everything's going to happen right now. That's what they're worried about. They have good cause to be. That's what all this is about. That's why they're trying to do these things, to bind the next action, because they're afraid that if this convention goes on, they're just going to do everything, not have any in-person anything, violate the spirit of the agreement between the LNC and the delegates, and cause all kinds of havoc. Let's see where it goes.
Okay, well, we're past that now.
Raise an objection to the consideration of the question.
Yeah.
This is Mr. McVeigh speaking through Mr. Gowert's connection.
Mr. McVeigh, what prior ruling do you have that was not resolved?
You ruled that it was out of order for me to object, or that you were, it was not well taken, rather, for me to raise a point of order regarding the voting threshold for amending the agenda. You said that since there was a special rule already in place regarding the agenda, that it did require a suspension of the rules. That's the ruling that I'm appealing, sir.
Yeah, I did. I thought that was all part and parcel of the previous ruling.
It was not.
Well, you're going to have to get in line because now I have this appeal. So
this is for an earlier ruling, though, sir. I believe if this ruling is resolved, then the current ruling would be moot.
No.
I thought the ruling from the appeal from the chair had been decided. Maybe the secretary can recall.
I believe that I had resolved that issue in the previous ruling.
Except I appealed that ruling, sir.
You can't appeal the ruling if my ruling was sustained.
That's not one that was appealed, Mr. Chair. The ruling that we're talking about is the one that you made, that an amendment to the agenda was a suspension of the rules rather than an amendment motion to adopt the agenda. You ruled that there's a standing order. However, the standing order says that item number 3 on the agenda is the adoption of the agenda. And since we're in that stage right now, then amending the agenda should not be a suspension of the rules, but rather should be an amendment to the motion adopting the agenda, only requiring a simple majority rather than a 2/3 vote.
Mr. Brown, does that sound right to you?
Mr. Chairman, I don't recall if there was actually an appeal on your ruling that it requires a 2/3 vote to amend the order of business.
They're gonna wear me
It is in the convention standing rules. I mean, that is my opinion as well. I do not recall whether there was an appeal from that.
I mean, so
the appeal that we had prior, Mr. Chair, was.
Stop, please stop.
All right.
I understand what you're saying, Will, and so let me try and make it clear for the parliamentarians so we can hopefully get an answer. What Mr. McVeigh appears to be saying is that because the convention has in their standing order of business the adoption of the agenda, that adopting the agenda is not in fact a suspension but a simple majority in the same way as an initial credentials report. Is that the case, Mr. Brown, or do you believe that that is not the case and it requires a suspension?
I believe that's not the case, and it would require a suspension because it actually is changing the order of business as specified in the special rules of order. And just as in any other case, when you're suspending the special rules of order, it would require a 2/3 vote, in my opinion.
Okay, so I would like to resolve that appeal after we resolve the appeal that I was dealing with Dr. Olson.
I'm sorry, Mr. Chair, but again, I believe that if we resolve my appeal, that it will render the current appeal of Mr. Olson moot.
But here's the thing. I'm not going backwards because you want me to. So we're going to take these things in the order that I'm taking them.
Mr. Chair,
Ms. Harlos.
I will note that my minutes note, or my notes, that you did mention the 2/3 in your ruling.
Okay. I thought I did, but we can do it again, but we're not doing it again before we deal with Dr. Olson's motion to appeal the ruling of the chair that it is not in order to move to adjourn this meeting to a date and time certain in advance of adopting the agenda.
Mr. Chair, I will concede that that's more in order than my current appeal.
Okay, thank you. Would somebody who wants to appeal from that ruling like to speak to it? Ms. Robeson, please feel free if you would like, if Dr. Olson's still not available.
Mr. Olson has gotten, or Dr. Olson has gotten back on the call. If he could be unmuted, he was able to get back in the meeting.
All right,
Dr.
fine. Let's hear what Dr.
can
Olson has to
speak
say.
to why my ruling should be overturned and why it would be in order to move to adjourn us to a date and time certain in advance of adopting the agenda.
Okay, so in Roner, page 233, line 9, a motion to adjourn may be privileged or a main motion depending on a number of conditions. And then further on in line 17, the privileged motion to adjourn, which is always moved in an unqualified form with no mention of time either of adjourning or for meeting again, is a motion to close the meeting immediately, made under conditions where some other provision or another meeting exists, so that the adjournment will not have effect of dissolving the assembly, and where no time for adjourning the present meeting has already been set. In such a case, regardless of whether business is pending, a majority should not be forced to continue in session substantially longer than it desires, and even if no business is pending, a decision as to whether to close a meeting should not be allowed to consume time. For this reason, when there is a provision for another meeting and no time for adjourning is already set, an unqualified motion to adjourn is afforded sufficiently high privilege to interrupt the pending question and on motion to close the meeting before the pending business is disposed of. And for the same reason, such a motion has the unique characteristic that even if it is made while no question is pending, it is not debatable or amendable, and it remains subject to all of the rules governing the privileged motion to adjourn, except those that relate to making the motion while business is pending. See standard descriptive characteristics. Under the conditions just described, a motion to adjourn
This is
therefore said to be
clearly
privileged
intentionally
or to be
dilatory, by the way,
privileged
guys.
motion, even when no question is pending.
Okay, is there anyone else who would like to be recognized to speak to whether or not the ruling of the chair should be sustained?
This is Carolyn Wade from Oregon.
Go ahead, Ms. Wade.
If he had read further, it would say a motion to adjourn is always a privileged motion, except in the following cases. And number 2 is when a time for adjourning is already established, either because the assembly has adopted a motion or a program setting such a time, or because the order of business, the bylaws, or other governing rules prescribe it. Well, we have a standing order of business, and under the standing order of business for convention, the adjournment will follow after we cover what's already under the standing order of business.
Good God. Don't worry. We'll go over this in a sec. Let me get the rest of this.
I would like to proceed to a vote on this appeal from the ruling of the chair.
Personal privilege.
Dr. Mott.
Mr. Chairman, we had put in a request for a substitution of an alternate for a delegate who's off the floor and not gotten back a response. I know there's supposed to be a special number to communicate this kind of information, but I did not receive that number. And so I'm appealing to the chair. How do we go about it?
I will follow up
Not only
with
for
Mr.
myself,
Mod.
but for anyone else who's in that position.
Okay.
Mr. Chair, I hate to interrupt, but I can't do Q&A. I have my hand raised, but I know that there's others that have their hand raised to actually discuss this further based on other points of RONAR that Dr. Olson did not
Well,
mention.
we're only discussing whether or not it's in order for him to move to adjourn to a time and place certain in advance of the agenda being adopted.
I understand that. He appealed your ruling.
Right.
If I can speak to that, page 242 of Ronar basically says a motion to fix the time to which to adjourn is in order only if the time is offered. There is no meeting scheduled for later within the same session. If there is such a meeting, additional meetings with the same session may be set by a motion either to suspend the rules or to amend something previously adopted, namely the previously adopted agenda on our program. A motion to fix a time to which to adjourn is privileged only when it was made during a question. So I believe that what he's doing is he's not asking that we adjourn at this time, but I believe what he's asking is that we will, at this time, set where it will be adjourned to. So when this meeting adjourns, it's already set that it will in fact reconvene at a time and place certain. And I believe Alicia Mattson also wished to speak on this.
And
Thank you.
I have my hand up as well, Mr. Chair.
I don't even know if we have a speakers list for this.
No, we don't. That's why I interrupted. Thank you.
Go ahead, Ms. Mattson, and then go ahead, Ms. Harlos. Mattson first, Harlos second. Is Ms. Mattson not able to speak?
I believe she's
okay,
here.
so I've got it mic now. Actually, Ms. Robeson covered it really well. The page 242 was what I was going to bring up as well, that it is precisely in order at this time. This is page 242, lines 25 to 33. If you'd like to flip to it and double check what she read off, but it is specifically in order when there is no meeting scheduled for later within the same session. We are in that situation, and it matches the circumstances for when it's a privileged motion. So I just.
All right, guys, let's not get too lost in the weeds. Here's what's happening. You're having the people who know the most about Robert's rules just like use their legal knowledge to try to go back and forth with each other. Nick knows a lot about it. Alicia Mattson knows a lot. Will McVeigh knows a lot about it. These are the pros, the experts that know the most about this topic of anybody. Here's what you need to understand, what their goal is. Their goal is to, some people want to do all the convention stuff right now. Platform, bylaws, everything. Other people want to make sure that we have an in-person convention later on. So each is kind of trying to bind the other side in some way to make that happen. Don't get lost in the weeds here. That's the intention. They're going to battle it out with their legal knowledge.
Agree with everything that Mimi said, and I believe this motion is in order.
Are we prepared to move to a vote, or do people want to keep talking about this? Ms. Harlos, go ahead.
Okay, and I won't repeat the things already said. I'm just going to supplement it and refer to the same pages, but there are standard, I believe Dr. Olson, he worded his motion not exactly correct. It wasn't a motion to adjourn, it was a motion to fix the time to which to adjourn, which makes all the difference in the world. On page 243, it says in an unqualified, the sentence does not have any qualifications, that it takes precedence over all other motions. That would include a motion to adopt the agenda, because it does not dissolve the assembly at this time, and we can still proceed to adopt an agenda. And if the chair's position is that this is a regular convention with all of the things to happen are supposed to happen, then there is not yet another time set. And it is in order to set the next time and to say what business will be adjourned to that time. So I believe it's very, very clear in Roberts that this is in order.
Mr. Chairman, upon doing some further research, listening to the arguments, and I think the motion was initially rather poorly worded. But what it is, in essence, is a motion to fix the time to which to adjourn, which is one of the most privileged of the privileged motions. And I think that it would be in order at this time.
So you guys see what happened over there. Depending on how you phrase, it's just like with the law, depending on how you phrase things can be right or wrong. So he said he wanted to make a motion to adjourn. Nick ruled that out of order because you haven't started the meeting yet. Adjourning is a little bit premature. But to fix a motion of when and where to adjourn, when that actually does happen, is a much higher privilege motion. He changed the legal argument a bit with a little help from the most expert people who know the most about this, Alicia Matson, Karen Ann Harlows. And with that adjustment, all of a sudden everything changes. The parliamentarian has agreed with them. Let's see what happens now.
I am going to persist in the idea that it is not in order to set the time for adjournment
Oh.
before we've set the order of business.
All right, Nick is disagreeing.
It is not in order at this time. That is my ruling. I would like to proceed to a vote on it so we can just get done with it. So let's do that. If you want to sustain the ruling of the chair that it is not in order and we can go back to motions to amend the agenda, vote yes. If the ruling of the chair should be overturned and it's in order to, if you believe that the ruling of the chair should be overturned and that we should consider this motion to set a time and place for adjournment of this meeting to a fixed time and place certain, before we actually adopt an agenda for the convention, vote no, and then you also have abstain. Whenever we're ready.
So there's not voting on actually setting the time and place. It's voting on whether or not it's allowable.
Can. Let's move forward.
Let's jump to the present. All right, and it looks like they're voting on whether or not they are allowed to do this.
20 minutes. We have a question regarding the original agenda. Could we see it, please?
The original agenda, I think the secretary has the order of business on the screen. It should be up. We have about 10 seconds left in the poll. I'm going to get through 2 minutes of elapsed. Let's see the results. 577 votes to sustain the ruling of the chair, 311 votes to overturn the ruling of the chair, 40 abstentions. The ruling of the chair is sustained. Dr. Olson's motion is out of order. We will now move to clearing out the privilege motions.
Mr. Chair, at this point, I'd like to move to reconsider my appeal.
No, Mr. McVeigh, you are
Sorry
not.
about that. I'd like to come back to my appeal.
Mr. McVeigh, please stop.
I'm sorry, Mr. Chair, there was a sound issue on this end. What
Yeah,
was
but you don't get to be recognized out of order. So I'm going to get through the privilege motions and then we'll come back to your appeal at that point.
Raise your hand.
Arizona Delegate John Buttrick requests a point of information as to whether the second sitting is meant to refer to tomorrow or July 8. It refers to July 8. Mr. Wentz' motion is not privileged. I'm sorry.
Point of order.
Yes.
Dalton Brown, North Dakota delegate. I've noticed that John Phillips has moved from the speaker's queue to second place after remaining at the top of the list for the past 45 minutes.
That's not a point of order.
Okay.
Illinois Delegate John Phillips has a point of parliamentary inquiry. If this is a convention, is there a need to ratify it at a later date? It is my opinion that there is no need to ratify any actions that this convention takes at any later date because this is a convention.
Okay, Nick is saying, all right, guys, look, see what's happening over here.
Order.
We got to pause this one, guys. This is a big one. Nick is saying that there's no reason to have a ratification convention at all. Now, why would anyone bring that up? That says to me that Nick is hoping to do the full convention right now. Personally, I don't think that's a terrible idea because I'm not sure that things are going to be any different in July. Nick also believes, based on what I've heard him say previously, not that he said anything to me specifically about it, but from what I've heard him say previously, he also believes that it's not going to be any different in July. We're going to still not be able to have a big giant meeting, and if we did, it would put people who are immunocompromised, etc., at risk. So what he's doing is setting the stage to try to make this a full convention, covering everything, pilots, platform, etc. That's what I think he's doing. The other folks on the other side are trying to make sure that he doesn't do that. They want to have just the nomination now, and that's why they're doing all these motions to make sure we have this secondary convention. And Nick is trying to make sure that we can do everything right now and get it over with.
delegate Francis Went. Sorry, Mr. Went. If you have a point of order, go ahead. Just gotta find it.
Yes, my point of order is that, as I raised earlier, the delegates are still utilizing their ability to unmute themselves in a method to jump the line, and I firmly request that the panelists stop using that ability to circumvent the other delegates. We have the same rights. You do not get the ability as a delegate chair to circumvent our rights. Thank you.
Thank you. Tennessee delegate William Helmstetter raises a point of parliamentary procedure. Why are the same three people getting to speak and ignore the entire delegation? Please stop abusing the mute and unmute. There is a point of procedure or a point of privilege that Mr. Abernathy continues to abuse the Q&A, and there is a request that the chair remove him for the duration of this online session. I will not remove Mr. Abernathy at this time, but the next time the Q&A is abused, we will move to an immediate vote onto whether or not Mr. Abernathy should be removed, and the delegates will decide whether or not he gets to continue to be part of this convention.
Point of information.
Yes, Mr. Williams?
Did I hear you correctly and say that you ruled that a ratification at a later in-person convention is not necessary?
Yes.
I will then raise a point of order that under our bylaws, this online meeting, as ruled by the LNC, is to be not a place of convention, therefore negates any decisions made here as being bona fide in a convention, and therefore require a ratification at convention by Robert's rules.
All right, well, if you would like to get in line, Mr. Williams, you can have the next appeal from the ruling of the chair after Mr. McVeigh's ruling appeal is done.
There's going to be a lot of these appeals.
I have a point of order from Mr. Starr from California.
Oh, good God. What do we have now?
Mr. Starr. Mr. Starr, did you have a point of order? Mr. Starr, go ahead with your point of order.
Thank you. That it just popped up right now that I can unmute myself, so I wanted to answer you. I'm sorry, I just couldn't. My point of order was that you just unilaterally decided to close debate and go to a vote. You need to ask people to close debate first. You made a decision. You can't do that. You got to give people an opportunity to debate, or ask them if they're willing to close debate at least. But you can't just say we're going to a vote. It's just out of order.
I believe it was in order. The arguments were repeating themselves.
There was only 2 arguments. That was it. Nobody, you didn't have people arguing yet. You didn't get a chance for people to debate.
Is there any other point of order that you have?
No, I'm just saying you're not giving people, you're squelching debate. You can't decide on your own to close debate. You have to ask this body to close debate. You cannot make that decision unilaterally. That is not in your purview. You just can't do that.
Sharing your opinion, Mr. Starr.
No, this is Roberts. You need to give people an opportunity to debate. Otherwise, this is not a convention.
Thank you, Mr. Starr, but you have raised a point of order, and so you will not be given any further opportunity to debate at this time.
I'm not asking to debate this. I'm simply mentioning that you're violating people's rights by not letting people debate. You are forcing votes when people have not been asked if they're ready to close debate. You can't do that.
I believe your point has been made, Mr. Starr.
Thank you. So please keep in mind. Thank you.
Thank you, Mr. Starr. There's a point of order from Mr. Zimmerman about this speakers list. It's within 2. Let's not do this. There's a point of personal privilege about getting kicked out of Zoom. I think that goes through your delegation chair. Ohio delegate Donald Kissick has a request for information.
Mr. Chairman, your results, reading of the results were inaudible on the vote recently about your whether to sustain your ruling. I was hoping you could repeat that.
577 to sustain, 311 to overturn.
Thank you, sir.
You're welcome.
All right, let's get it caught up with these guys.
Delaware who would like to appeal the ruling of the chair that it is required to have 2/3 to amend the agenda. We have Mr. Williams from Oklahoma who would like to appeal the ruling of the chair that this is in fact a convention and the delegates here are authorized to conduct business. So we will move through those appeals in order, and then we will get back to the speaker queue for business.
All right, guys, we'll come back to this in a second. Here's what's happening right now. We're seeing a situation in which you have two sides that are trying to make their way happen by using these techniques. One side wants to make sure there's an in-person convention. That side actually wants there to be an in-person convention and no online convention. The other side wants to be able to do everything online right now. The argument for that is that in terms of this COVID stuff and whatnot, a lot of people don't think it's going to be any different in July than it is right now. Plus, a July meeting is going to put us over the limit for a couple of states, or at least that's what's been argued. So here's what they're going to try to do. Some people are trying to kind of prove their point that an online convention won't work by making the online convention not work. They're trying to be dilatory, stall things, and that's why you're getting these 57, appeals from the ruling of the chair and all that kind of stuff. What the other side wants to do is say, listen, we can do everything right now. Let's just make it happen. One side wants to say, let's make sure we have an in-person meeting, and that's why you're seeing so many appeals from the ruling of the chair. Listen, I've been in Nick's shoes. I've been the presiding officer for the Libertarian National Convention. It is not easy under the best of circumstances. I've done it for contentious votes. It's really hard. This is incredibly hard because you're dealing with a different setup, the online situation, plus a lot of people who are trying to make the convention simply not function. When you have an in-person convention, everyone basically at least agrees that they want the convention to work, even if they disagree with each other, right? Here, a lot of people want the online convention to simply not function at all, and that's where you're going to get a lot more of these antics. All right, let's get caught up with these guys.
What I would ask is if we would like to, I believe the set of hands we have now is for appeals from the ruling of the chair. So Massachusetts delegate Ashley Shade, go ahead. Massachusetts delegate Ashley Shade, have we been able to get you unmuted?
Yes, I believe so.
Go ahead.
Yes. As far as speaking to this appeal, I believe that your ruling is correct, and I will vote in favor of that ruling.
Thank you, Ms. Shade. Colorado delegate Karen Ann Harlos.
I would argue against your ruling for this purpose is that it is contained in a convention rule, but convention rules can be amended by 50%. So I don't see a reason why when we're in adoption of the agenda, it would require an even higher threshold. It seems to me that 50% is in fact the correct threshold. Once it is adopted by the convention, then it becomes a suspension of the rules. But at this portion, I do believe that Mr. McVeigh is correct, though I come to it by a slightly different reasoning path.
All right. Texas delegate John Wilford.
Move the previous question.
Oh, thank God.
Wilford would like to close debate. It's been requested for a point of information in the past that I tell people how many people are on deck. I have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, roughly on deck. We will move to a vote on whether or not to close debate on the appeal from the ruling of the chair. A yes vote will close debate and move us to a vote on the appeal from the ruling of the chair. A no vote will allow debate to continue. Please do such a poll. I am stepping away from my computer long enough to get a glass of water, but we can put that poll out for 2 minutes. A
All
yes
right.
vote will
That's
close
fair.
debate. A no vote will allow us to continue debate.
All right, guys. So we've been doing some coverage and analysis of this. I think right now we're basically caught up. So we're going to take a little pause from the stream. I'm going to be back in a bit. I'm sure these debates are going to be going on for a while. Here's an important thing to know, though. If you have your nomination tokens, turn your nomination tokens in. Listen, about 100 of the debate tokens never got turned in. So that means you have a right to speak and influence the course of history here. Make sure you use it. Now, debate tokens, you need to have a lot of tokens. You don't need a lot of nomination tokens. So if you favor one of the favorites, Hornberger is gonna get enough nomination tokens. You don't have to worry about that. If you want to support the one person who's gotten an A grade from the Libertarian Party Radical Caucus, that's me. I would, of course, appreciate it. If there's somebody else who's a dark horse you want to support, do that. Let's make sure that we get all points of views in the nominating speeches. The debates were just terrible. I mean, just terrible. The vice presidential debates, I think the total number of cuts that people discussed in terms of cutting government was like 6 in the entire hour. The presidential debate was a little bit better, but you had even people who are usually kind of pushed to be a little bit more hardcore taking these very moderate positions, talking about how they want to keep the State Department going and all that kind of stuff. Listen, the reason they could get away with that is because in the debate, Adam Kokesh wasn't there, I wasn't there, Dan Berman wasn't there. None of the hardcore principled radicals were in that debate, so it allowed the people who are a little bit more moderate, people like Hornberger, Jorgensen, even Mons, to become even a little bit more moderate. You need to have the radical voices to make sure that we push that kind of radicalism. So please, even if you don't turn in your nomination token for me, turn it in for somebody. Don't not use your nomination token. All right, guys, we're going to be back in a little bit with more analysis of what's going on over here. I'll talk to you guys soon.